Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will unpack what if an employee is dismissed for joining a union and participating in its lawful activities. What are the applicable legal considerations and implications? This question was answered in the matter of AMCU on behalf of Maserumule and 4 others versus Gold Plat Recovery Proprietary Limited, when AMCU contended that 5 of its members were dismissed by the company during August 2016 for joining and actively campaigning for their fellow employees to join the union AMCU. The company's workforce was historically not unionized. Instead, employees were represented by a workers' committee, a consultative forum elected by the workforce to engage with management on concerns of grievances raised by the workforce. The workforce, however, had apprehensions about the effectiveness of the workers' committee and perceived it to be an instrument of management. During 2015, AMCU began recruiting members in the company's workforce. By 2016, AMCU had made significant inroads and it therefore requested organizational rights from the company. At the instance of the company, an independent institution was engaged to conduct a union membership verification exercise to determine the level of membership held by AMCU. The verification exercise found that AMCU had 23.3% of the workforce as its members. AMCU thus commenced a recruitment drive to secure additional members. During the recruitment drive, management was approached by 3 employees who alleged that AMCU members were threatening and intimidating employees to join the union. On the 31st of August 2016, those union members accused of threatening and intimidating employees into joining the union were summoned individually to the company's boardroom and were handed letters indicating that they had been dismissed with immediate effect. These letters had already been signed by management. AMCU sought to challenge the fairness of the dismissal of its members, claiming their dismissals were automatically unfair and in breach of their right to freedom of association. The company defended its actions by expressing fears of a potential repeat of the Marikana massacre during 2012. The Labour Court found that there was no evidence that those union members were guilty of intimidating employees and their dismissals were motivated by their union activities. Thus, the court found that the dismissal of the 5 union members was automatically unfair in accordance with Section 187, read with Section 5 of the Labour Relations Act. A closer look at the applicable legislation rather makes it easier to understand why the court made such findings. Section 4 of the Labour Relations Act grants all employees the right to join a trade union, subject to the constitution of that union. Section 4 further grants all union members the right to participate in the lawful activities of that union. Section 5 prohibits discrimination against any employee for his or her exercise of a right conferred by the Labour Relations Act, such as the right to join a union. Section 5 further provides that no person may be prejudiced because of their membership of a union. Section 187 states that if an employer, in dismissing an employee, acts contrary to Section 5, that dismissal is automatically unfair. And Section 187 further states that if the reason for the dismissal is because an employee exercised a right conferred by the Labour Relations Act, the dismissal is automatically unfair. Consequently, in dismissing the union members in the circumstances, the company violated the rights of those employees, particularly their right to freedom of association, as enshrined in the Labour Relations Act. Given that the exercise of their rights was protected, their dismissals amounted to an automatically unfair dismissal. The court ordered the reinstatement of the 5 union members with back pay. Ultimately, what this judgment does is that it simply reaffirms the protected right of an employee to join trade unions of their choice and to participate in the lawful activities of that union. Any dismissal that may arise from the exercising of such rights will be deemed automatically unfair, and in the absence of any evidence to the contrary, the primary remedy of reinstatement will be awarded. Colleagues, that brings us to an end of this week's episode. Thank you for joining us. We hope you have found the discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.